real partners is a matter of EOG and KTT and the second stakeholder partners.
Yes, good morning, Mr. Tan.
Good morning, Lords. Please the Court, I'm grateful for the time that we were given to check the precise position on one matter to make sure that our position can be clearly stated. And Lord, we have taken instructions and I hope that it will help to set out clearly what our position is. To introduce this, to make sure it's properly understood, can I invite the Court please to go to Mr. Justice Linden's judgment. At paragraph 28, it's 4-bundle page 304.
Yes, sorry, Mr.
Yeah, don't worry.
Which paragraph?
It's page 304, paragraph 28, where Mr. Justice Linden analysed the concession in PK Garner. We've been referring to it as a concession in the singular. But as in many things, we are grateful to Mr. Justice Linden for the careful analysis which he made, because he pointed out that there were two concessions. One, as a matter of fact, the policy of the government was to make decisions as to DL in accordance with Article 14. Second, that as a matter of law, failure to give effect to Article 14 would therefore be a justiciable error of law. So he's identifying the two different things that have been conceded. The same analysis applies to JP and BS, which you'll see at paragraph 30. It's on the very bottom of that page. And there's a quotation from the judgment of Mr. Justice Murray, and at 31, he says, as Mr. Justice Linden says, I note that the concession in JP was twofold. First, it was positively pleaded that as a matter of fact, the policy gave effect to Article 14. Second, the legal proposition conceded in PK Garner was conceded again on the basis that the defendant was constrained to do so, presumably because she accepted that that decision was binding. Not sure that that was entirely correct, but it doesn't matter for present purposes, the reason for the constraint. Having analysed it like that, your Lordships will notice that when, after having concluded that in his own view the PK Garner point of view was correct, he then did look at the question of precedent as to whether or not it was bound. And that this is the passage starting at 53, paragraph 53, page 310. And you will see at paragraph 54, first line, that he's discussing the concession of law. At 55, it's the concession of law. That's also the first line. At 57, first line, is the defendant's concession of law. And then at 59, his conclusion, having looked at all of that, was that the defendant's decision was potentially justiciable. And sorry, I should have said he regarded himself as being bound in any event by Galdikas and by PK Garner. So that part of it deals only with the concession of law. And then, in the next section, he turns to the question of whether the defendant's policy is was to make decisions in accordance with Article 14. So then turning to the question of fact. And on that question, you'll see that paragraph 61, line 2, he's talking about conceded by the defendant that as a matter of fact, policy statements were intended, and at 78, this is going on.
So you were at 60 a minute ago, and then you've gone to 78. Where did you go in between?
It's, this passage starts at paragraph 60 under the heading, was it the defendant's stated policy? And it's clear that in this section he's looking at the question of fact.
Well, I think the answer to my Lord's question is you then went to 61.
I'm sorry, I must have misheard the question, yes. Then went to 61 as second line.
The phrase as a matter of fact.
As a matter of fact.
Line,
Right, and then at the bottom of page 315, paragraph 78, he says, the factual concession made in PK Garner and pleaded in JP is therefore unsurprising.
78.
78, yes. So, Mr. Justice Linden was carefully distinguishing between those two. It's the point of law that is the binding part of the ratio so far as future cases are concerned.
So it is the point of law which is the binding part of the ratio.
Yes. The point
whose
of the
ratio?
proposition.
Sorry, the PK Garner ratio.
That, yes, or in the abstract, when a court is looking to find out what is binding in a previous decision, the binding part of the ratio is the proposition of law that the court has decided.
So can we just revisit that? The factual concession is that it was the defendant's stated policy to make decisions as to discretionary leave in accordance with Article 14.
Yes.
And the legal concession was
that if the policy guidance, or if policy guidance that was intended to give effect to the convention failed to give effect to the convention, then that would be a justiciable error of law. On that, on the question of fact, Mr. Justice Linden found against us. That's the conclusion of that section of the judgment, and that is part of our appeal. It is the ground 2 of our KTT appeal, which is the ground about general words can't be read to impose specific obligations. So that's where we appeal. But that's a question of fact.
I'm just trying to square in my mind how that is a question of fact. The question the judge answered was it the defendant's stated policy to make decisions as to discretionary leave in accordance with Article 14?
Yes.
And that is a question of fact?
Yes. And
it's a different question of fact from the one answered in PK Garner.
No, it's in essence, it is the same question of fact.
Answered in different circumstances.
But answered in different circumstances, and of course questions of fact don't bind subsequent courts.
No, but policies do, unless you say you've changed it. And if someone has said to a court that their policy was to make decisions as to discretionary leave in accordance with Article 14 of ECAD, and this was reflected in the documents under consideration, including the discretionary leave policy, one would expect to have seen a change of written policy if the policy had changed.
Well, Lord, what I would accept is this, that the meaning of the policy is something that may bind a future court.
That's a different
but the
point.
question of whether the policy was intended by the policy maker to do X, Y, or Z, in our case, to give effect to Article 14, is a question of fact.
It's a rather peculiar question of fact. I can see why you say it's a question of fact as opposed to a question of law. But as my lord says, it is in fact a public statement by the person about whose intentions, with whose intentions we're concerned, about what his or her policy is. And having said in terms what their policy is, you can't say, oh, well, it's only a question of fact, and a different court can reach a different conclusion about what their policy is, unless they have formally resiled from what they previously said. And that, I think, the Secretary of State has never done.
In this appeal, I would, with respect, not accept that. What I would accept is that if the Secretary of State has publicly said, my intention in this policy is to do X, Y, and Z, that for future cases, that will stand as evidence that that is the Secretary of State's intention. But it doesn't change the nature of the question being asked, which is, as a matter of fact, is it the Secretary of State, or was it the Secretary of State's intention to do X, Y, and Z?
I don't understand that submission. You're going to have to take that very much more slowly for me. I mean, I got halfway through it, and if the Secretary of State has publicly said that her intention is to comply with Article 14, right? Let's not say X, Y, and Z. Let's talk about the case, right? If she's publicly said that her intention is to comply with Article 14, that will stand as what?
Evidence that that is her intention.
Yes, but
well, there's no but about it.
You said but.
The proposition is that it doesn't change. I suppose that's where the but comes in, but it does not change the nature of the question. Is it the Secretary of State's intention? That is still a question of fact.
I speaking for myself, entirely understand those two propositions. But if you have changed your intention, or it was misreported beforehand, one would expect to see written down, expressed somewhere, that my intention has changed. But we haven't seen that, or maybe I've missed it.
What was said in PK Ghana and in JPMBS was a concession. It was either a concession in the case, which would not be binding in future cases, or it may be a statement that itself stands as some evidence for that question, on that question of fact. So that is the strict analysis of where we are with that. Can I, having set out that introduction,
where are we today?
To tell you what our position is? We repeat the concession of law made in PK Ghana. We actually probably have no alternative because it's binding on this court, but we do. And at this level, that is settled. But we do not repeat the admission of fact that the parts of the policy in question were intended to give effect to Article 14(1)(a). And I
Hang on one
stress...
second, sorry, I just want to be rather slow. You not repeat the admission of fact
that the parts of the policy in question were intended to give effect to Article 14(1)(a).
Notwithstanding that your evidence in the case, in Mr. Bramley's witness statement, is that it was.
Well, what I was going to go on to was that Mr. Justice Linden, we accept, found that fact against us, and he had evidence to reach that conclusion. But it is our ground too that he was, with respect, wrong to do so.
But the grounds on which we will interfere with findings of fact made by judges at first instance, you having rightly teased out what is fact and what is law, are very limited. You've got to show effectively that it's an irrational finding or he's failed to take into account relevant evidence. Where's that?
Well, the fundamental submission that we make is that when you analyse what is being said against us, there is nothing that is sufficiently specific to establish that finding of fact.
Can we just remind ourselves of what Mr. Bramley did say? I think it's page 412
In the core bundle.
in the first supplementary bundle, I think. Sorry.
413.
So those of us who have to use paper, it always takes longer. 413, paragraph 12, starts by explaining how the question of DL arises. Says it's based on the policy set out in version 2, what we've been looking at. And then it says in the third sentence, the policy exists to reflect the requirement in Article 14(1)(a) of ECAT to consider whether a grant of discretionary leave is necessary owing to the individual's personal situation. Would that most naturally be read as a statement that your policy is to give effect to Article 14(1)(a)?
On that specific question, my argument is that reflecting a requirement is not the same as using the policy to implement the requirement. That's the
So you need to say that more slowly as well. Reflecting a requirement, which is the words that he uses, yes?
is not the same
Yeah.
as saying is not the same as implementing Article 14(1)(a), which is where one would need to get to as a matter of fact to allow the justiciability. That's my argument. There is another point about Mr. Bramley's witness statement, which is that it is evidence in EOG, but it's not evidence in KTT. But I accept that if it's permissible for the court to be looking at statements from all over, and we've got 4 bundles of policy which learned friends will no doubt be looking at, that may be evidence that this court will take into account. I recognise the principles about this court interfering with findings of fact below, that's I can't gainsay those. But this, properly analysed, is a territory in which this question lies. I don't repeat the concession of fact that was made in previous cases. We have permission to argue this, and that is the argument. And we acknowledge the court will make a decision on that. If that decision is adverse to me, of course, then the consequence is that the court will properly be able to look at Article 14(1)(a), what it means, and judge whether or not the two are compliant. And I've made all the arguments about that. Lord, that was quite a long way of answering the question, but I hope that explains our position adequately and sufficiently clearly. So unless I can assist any further at this stage, those are our submissions and open.
We'll just rise for 5 minutes.
Yeah, absolutely. I've basically seen them everywhere.
Thanks very much. I might need help with sort of big page references and space. It's okay. That's okay. You're more important than that. Yeah. Just who's got the timeline?
The timeline being everyone should have that. Thank you so much.
But where are the court's copies?
They've been handed up.
Oh, have they?
And an electronic version is going to go via whichever email address we can find the right email address next to it.
So it's already got one.
Just Underhill's class. We don't have the other class email addresses, so that is version 6.
Thank you.
Yeah, exactly. Well done. Keep it better.
Have you got any idea how long? I use that word advisedly.
I'll be as long as they can tolerate being, subject to whatever interventions they do. I mean, I expect that this 5 minutes is with a view to telling me what they want to hear from me.
Yeah.
Yes, Miss Weston.
My Lords, it's stark in my respectful submission that Mr. Tam, the Secretary of State, has not resiled in EOG's case from the government's commitment to meeting its Article 10 to 13 obligations through the NRM and associated guidance.
Yes.
As he has in the context of KTT's case. Picking up on the court's observation that a timeline of statements of policy would be helpful, one has been prepared by Milena Junior and Ms Butler overnight, and it's a sort of timeline collated from the evidence already before the court. I understand that Ms Wilston, the Secretary of State, has kindly forwarded that in both hard and electronic versions. It doesn't contain any new information in there, it's merely putting in order of time the various expressions of policy commitment or policy intention which are contained in the documents before the court, and indeed summarised helpfully by the intervener in paragraphs 6 to 7 of their updated submissions, which can be found in the supplementary core bundle.
Right, just help me with what the two pieces of paper I've got in front of me, which have not yet arrived electronically, are. The one is the summary of the various policies, is it? That's the one with boxes?
Yes, the one with the
and
table.
The other one is what? Is the discretionary leave policy?
That's nothing to do with me. I don't know why that's been handed up.
Well,
sorry, you were giving a reference to the interveners. Which paragraph did you say was?
Paragraph 6 and 7.
Thank you.
Summarises the key points at which the Secretary of State has made, Her Majesty's Government has made commitments to implement Articles 10 to 13 through the NRM and associated. And it's that policy we say is in play, that policy commitment which hasn't been resiled from by the government. So when Mr. Tam says in his skeleton argument at paragraph 4.27, or bundle, page 18, that EOG might contend that if the Secretary of State commits herself in her policy to follow ECAT, then this gives EOG a domestic law right to expect that the Secretary of State will abide by that policy. Now he then goes on to say, and I think it's a species of the high and low policy argument that he was making yesterday, that the relevant policy in question is the discretionary leave policy. And my submission is that's not the relevant policy to which we're holding the Secretary of State to account. That's the guidance issued to the decision makers in pursuance of the policy that we do rely on, which is the policy of meeting the UK's obligations of 10 to 13, Articles 10 to 13 of ECAT through the NRM and associated guidance. And of course, the court might recall, or at least two members of the court might recall, that after we adjourned on the last occasion, we did ask the Secretary of State in terms if the commitment to meeting the requirements of Article 13, abiding by the requirements of Article 13, and delivering them through the NRM and associated guidance was still adhered to. And that document, I think, is in the back of the supplementary core bundle, the small additional bundle. For some reason, it didn't make it into the core bundle. But
Which page is it?
It's at
This is only 5 pages.
Oh,
it's
my
38A in the
core
supplementary
bundle
bundle.
is 123 pages.
Yes,
Page 82.
it's 82.
Respondent's response to the appellant's application to amend.
That's right. That's right. So then at paragraph 10 of that document, we've specifically asked whether the appellant adheres to the position that she gives effect to her obligations under ECAT through relevant policy guidance, and the reference there are to the written answer, the part of the explanatory note to the MSA and to MS Pakistan, i.e. those places where, 3 examples of places where the Secretary of State has indicated, where the government has indicated what their commitment is in respect of Articles 10 to 13. And the response to that was not to give any indication that there was any resiling from that position. And indeed, Mr. Tam doesn't do so in this hearing.
Where's the response though?
It's in the core bundle at tab 2. Sorry. May I just turn my back for a moment? Oh, it's page 33 of the supplementary bundle. That's to say, the first volume of the large supplementary bundle. There are 2 volumes.
Supplementary core or the supplementary?
Supplementary.
It's a letter of the 18th of October 21
That's right.
to Duncan Lewis.
Yes.
Yeah, and paragraph 10 is the whole of the letter. I mean, I find that sort of mercurial.
Sorry?
I find that answer mercurial.
Well, indeed. But picking up on the observation of my Lord Justice Dingemans, if the Secretary of State or the government was resiling from such a well-established and trenchantly reiterated commitment, one would expect to see, in terms expressly, a statement resiling from that position, which we don't have, either orally or in the form of, as one might expect, a witness statement from a person authorised so to make.
Right, so you say they haven't resiled, and therefore the question for us is, what does Article 10.2 mean?
Yes, well, not just Article 10.2. The court will be aware that we have submitted 2 respondents' notices. The first makes the submission that we made in front of Mr. Justice Mostyn that was rejected on the basis of the effect of Article 13.1.
Yes.
And then the other, the second respondent's notice, which does deal to some extent with the question of justiciability, which is no longer pursued by the Secretary of State, but also places reliance on Article 4 and the Modern Slavery Act 2015. And its
This is Article 4 of the Human Rights Convention.
Correct, my lord.
Yeah, but I mean, forgive me, I was over summarising.
So
a very important point is their ground 1.
yes. How far does that sort of constellation of provisions get us? Does it was Mr. Justice Mostyn right to say that the consequence of those entitlements should be the remedy that we obtained?
You put it as a constellation of provisions rather than the Article 10.2 point.
Well, I think it's important to recognise that Article 10.2 is increasingly used as a form of shorthand. Why? Because it's a gateway to a constellation of rights and entitlements under 12.1 and 2 and 13.1. So when one talks about 10.2, one is also necessarily referring to those rights and entitlements which accrue as a consequence of meeting that threshold of having an RG decision and being entitled to the recovery and reflection period.
Right.
There was one point that I wish to start with, which we say is very important, and that is to distance ourselves from the Secretary of State's observations made yesterday that the claimant in this case had, and I quote, chosen a line of work which is known to be dangerous. We distance ourselves from those remarks and point out that the NRM guidance itself, which is a product of great learning, recognises that there are complex reasons why vulnerable people, and in particular vulnerable women, may fall victim to and cannot protect themselves from exploitation. For further information in this case, that was before Mr. Justice Mostyn, about how EOG herself had been horribly groomed and rendered vulnerable to exploitation, partly as a consequence of her childhood experiences, the court may find a summary of those effects at SB 405. I don't need to turn it up now. That's the supplementary bundle 405. And in this case, we are talking about coercion, assault, rape and false imprisonment consequences, very serious matters. And there was evidence available to Mr. Justice Mostyn of EOG's sustained efforts to find work, and we find those summarised at core bundle 45 in the solicitor's statement. And the court may have already had an opportunity to read through the statements of the claimant herself on the impact on her experiences. So that's the territory we're in, and that's what Mr. Justice Mostyn had at the forefront of his mind when he was looking at the impact of both the rights and entitlements under Articles 10 to 13, but also the impact of the long delay in reaching the conclusive grounds decision in this case. For the court's note, the factual chronology relating to EOG is at core bundle 17, and we can see from that EOG herself was granted 12 months discretionary leave, not 30 months. And she continues to assist the police and the CPS with the prosecution of her trafficker.
So that's an important point. Core bundle
17, core bundle page 17. The actual grant of discretionary leave itself, I understand, is not in the bundle. It's referred to in the chronology, but I can, if the court wants to see it, provide a copy of it.
So the respondent was granted a period of 12 months discretionary leave on the 11th of January 2021.
That's right.
Not 36 months. Is that accepted, Mr. Tam?
Well, we'll check. I've got no reason to doubt that is the case.
Well, you said yesterday it was 3 years, didn't you?
I'm sorry.
I thought you said 3 years.
I think you said 30 months.
That's 30 months.
What is in the policy is that discretionary leave, if it is granted on the kind of basis that we were talking about, I don't want to repeat the argument, but the kind of basis contemplated by the policy will normally be for 30 months. It's expressed slightly differently in the policy, but that is what is the case. As I don't have the precise reason why the respondent EOG was granted 12 months rather than 30 months, but you will notice that postdated Mr. Justice Mostyn's decision, and it is likely to have been a consequence of the judgment and the order that he
Okay,
gave.
thank you.
The next point I'd like to make is in response to the suggestion in Mr. Tam's submissions yesterday that somehow it was a matter of fortune that EOG claimed to be in a privileged position as compared with asylum seekers, or indeed as regards levels of support, was in that privileged position. The first reason I point out that that was wrong is that this was a claimant who had leave to remain at the point at which she consented to be referred to the NRM, so much as agreed. If she had been an asylum seeker, that's to say, if she had made a claim for asylum, the Secretary of State would have treated that as an application to vary her extant leave, and she would accordingly have had the benefit of Section 3C of the 1971 Act, which would have continued her leave in the terms in which it was granted, that's to say with the same conditions, including the ability to work, until the point at which a decision was made and any appeal was disposed of.
I'm afraid you lost me. What's the point you're making?
I'm making the point that actually an asylum seeker is in a better position than the claimant is, because the Secretary of State does not treat the NRM, entry into the NRM, as an application capable of affecting or triggering Section 3C of the 1971 Act.
Well, that's inherent in the policy. If you look at the policy, it says, it talks about more advantageous forms of leave, including asylum and humanitarian protection. So it's acknowledged by the Secretary of State in her policy that a victim of trafficking is not in such an advantageous position as somebody who's given protection for asylum or humanitarian protection.
Yes, but this is the point I'm making is what the status would be in the interim period. For an asylum seeker, the status in the interim period would be protected if they made an application for. So they would not. They should. The individual would not become unlawfully present in the UK with the gamut of.
Well, that's an asylum seeker who has already got permission.
Yes.
But I don't think this is a bit of a side issue to be starting your submissions with.
Well,
I mean, Mr. Tam was only making a rather general point about comparing victims of trafficking without any leave with asylum seekers without any leave. So I understood.
The point I'm making is that an asylum seeker in a comparable situation would actually be in a better position. So,
does this really matter?
Well, it does if the Secretary of State's making a point that somehow this victim of trafficking is seeking to put themselves in a better position than an asylum seeker would be. So, the next point is that also relates to the decision not to treat referral to the NRM as a means of continuing limited leave, because an asylum seeker would receive an ARC card, which would entitle them marked with the entitlement to work, because the effective 3C would have given them that entitlement. But it's also important to note that the distinction between asylum seekers and potential victims of trafficking in receipt of a reasonable grounds decision is that the purpose of the recovery and reflection period is to encourage and facilitate cooperation with a potential prosecution of traffickers, and thereby to meet the broader objectives of ECAT of deterring trafficking. And that's not something that asylum seekers have to face during the interim period while they're waiting for a decision. And it's an important aspect of the overall aims and purposes of ECAT within which the support and entitlement provisions under Article 12 are to be construed.
I take the point entirely. That's a peculiar element in the case of victims of trafficking. That's to say that they are given certain rights under the Convention related to assisting with prosecution. But I think the case law shows, and anyone one can see from the Convention, that there are two distinct elements. And even people who are not assisting the police in the prosecution, perhaps because there's no possibility of the prosecution or whatever, are entitled to a recovery and reflection period. So it's not something specifically and only for people, as your client happens to be, who are assisting the police. It has a more general purpose, which would apply whether they were or not. Is that correct?
That is right. But it might be helpful at this point to recall what was the remedy that EOG was looking for, because that's connected with the reliance we place on the overall overarching purposes of ECAT. What Mr. Justice Mostyn ordered, and of course we recall that appeals are against orders, was that the Secretary of State should give guidance to her decision makers as to the circumstances in which it may be necessary to regularise the immigration status of a potential victim of trafficking unlawfully present in the UK, whether that's because their leave had expired or because they were unlawfully present to begin with. And so whether the prolonged exposure to the hostile environment, as I use that as a shorthand, of a period subject to all the consequences of being unlawfully present in the UK, whether that had an impact on the ability of an individual to continue to support and assist the police or the CPS in bringing a prosecution. That's to say, the impact on their mental health and well-being and their willingness to remain involved is a matter which has a bearing on, we say, the question of whether the decision maker should grant some form of regularisation in the interim. So we are not saying, and we never went as far as I think it was recorded in the judgment of Mr. Justice Linden in KTT, of saying that Article 10.2, read with 12.1 and 2, mandated a grant of leave in the interim period. What we said was that there would be circumstances, and there were in EOG's case circumstances, arising from her loss of leave, her loss of work, and the consequences upon her that she and others have described in the documents before the court, would have a direct relationship with, and to some extent undermine, the aims and purposes of that period of recovery and reflection. So we say, in effect, that the Secretary of State's submissions about relative privilege and what have you fail to acknowledge that there is a clear relationship between the provision of support during the reflection and recovery period and the systemic aim of combating trafficking. And the sorts of material which has been referred to in extract in the skeleton argument on which we rely makes specific reference to evidence before Mr. Justice Mostyn that period of insecurity and all the gamut of consequences that flow for individuals in those circumstances does act as a disincentive for entering the NRM and does act as a disincentive for supporting prosecutions of traffickers. And it's in that way we say that there was a relationship, and there is a relationship, which the guidance failed to recognise between the aims of the Convention and regularisation of status. And when I say the aims of the Convention, I'm obviously talking about, in broader terms, about what the aims of the recovery and reflection period are. So Mr. Justice Mostyn was right, we say, to observe that the consequences of the protracted period without regularisation of leave for this individual were serious. And it's right, it's inescapable that a part of that was the delay involved. But again, it was no part of EOG's case that the delay itself mandated any particular form of leave. What was complained of was firstly that the Secretary of State had a rigid rule of excluding a potential victim of trafficking who didn't yet have a conclusive grounds decision from any consideration of DL, of discretionary leave. So much is clear from the terms of the policies themselves. That the guidance to the decision makers was therefore silent on that relationship that I've just identified. The relationship between the impact on an individual potential victim of trafficking entitled to all the gateway provisions of 10.2, 12.1 and 2, of that protracted period of insecurity and the impact on the aims of delivering and meeting the aims of the Convention. And it's that relationship, we say, that Mr. Justice Mostyn recognised, and it was in those terms that Mr. Justice Mostyn made the declaration that he did, which was essentially pointing out in an orthodox manner that the guidance given to decision makers didn't assist them in recognising that relationship. That is to say, what does it factor in a relationship, in an application to regularise status, that a person is not just a person applying under any policy, but a person with a particular identity, a status, and a set of rights and entitlements that flow from that, within the context of a broader objective, which may be undermined by that long period of insecurity. So, not only, on the state of the policies as they were, not only would a person in EOG's position not be considered at all for a grant of regularisation until the CG was reached, it's no surprise, therefore, that guidance wasn't provided to decision makers about the circumstances in which that interim status nevertheless required consideration of regularisation because of the constellation of factors that I've just referred to. Now, and of course we reiterate how central and important is the evidence in support of the victim in the case in the trafficking prosecution. Without it, the prosecution can't proceed. It's that fundamental to the aims and objectives of the Convention. court had made an inquiry about what document victims of trafficking are given when they receive their reasonable grounds decision, and we see that the decision in this case at Supplementary Bundle 331. I also, to try and ensure that this wasn't somehow an aberrant letter, I asked my instructing solicitor to find some other sample letters and redact them, which they've done, and so from around the same sort of time. And I have a couple here. I don't know if the court wants to see them.
So, I mean, are they different?
Well, they're broadly the same. The only thing that's different is that they state in terms, well, they do two things. They state in terms that the recovery and reflection period is provided for under the terms of the Council of Europe Convention ratified by the United Kingdom on the 17th of December 2008. And they include what I think was also included in our case as an annex, which is a notice providing help and support on returning home voluntarily. But apart from that, they are also completely silent, both on the question of irremovability, so there's nothing to inform an individual that they are not removable, or a third party indeed, for the foreseeable, at least until a CG is made.
Sorry, you were about to say.
I'm sorry?
You were about to say, I did have a question, but I thought you were going to make 2 points. I thought I'd wait till
Yes,
say.
so it's not only is it silent on the question for the individual concerned, it doesn't contain a positive authorisation either. So it
doesn't do what, sorry?
It doesn't provide any authorisation for the purposes of third parties. Something that somebody can produce if required to.
Mr. Tam said it was difficult to see how third parties would ever need to see such a document.
In my respectful submission, it's increasingly the case that people are asked to prove what their immigration status is, that they're lawfully in the UK.
By whom and for what purpose?
Well, it could be by the police, by immigration enforcement.
Well, immigration enforcement will know.
Well,
if they're showing something like this, they'll understand. That was Mr. Tam's point. Police, I'm not so sure.
Yes, landlords, the gamut of organised banks, the gamut of organisations.
You say landlords and banks, but will not someone only with reasonable grounds be provided with accommodation and will not be entitled to private, under the policy, will not be entitled to access private land tenancies?
That's right, I wouldn't support the submission by Mr. Tam that an individual didn't need to be able to demonstrate their presence, the lawfulness of their presence. In fact, a document of this kind wouldn't demonstrate lawfulness of presence. It would only...
I was just interested in the circumstances. I see the point, and you're entitled to refer to what the explanatory report says, but I just wanted to get into my mind the kinds of circumstances in which a potential victim of trafficking, not yet the beneficiary of a conclusive grounds decision, would require a piece of paper other than this that said in terms, until your conclusive grounds decision, you are irremovable from the UK, or whatever the phrase they chose to use.
Yes. Part 3 of the Immigration Act 1971 as amended contains a number of offences, some of which are are in force, not all of them are, but they relate to the offence of overstaying, for instance, and illegal entry, but also things like driving while unlawfully in the UK. Now that is an offence. Part 3 is quite large now. It's got a large number of different offences in there. But it's conceivable that a person driving...
I thought, sorry, I don't want to be, this isn't the most important part of the case, but they aren't allowed to drive anyway. They aren't allowed to have private land, and they aren't allowed to have bank accounts, or current accounts anyway. I forget exactly how the rules work. So the 3 examples you've given are ones that are not applicable to their situation. Police, I do accept, police may say, who are you,
Yes.
so forth, but are you entitled to be here? But I'm just wondering whether there are any other examples.
Yes. I haven't applied my mind to the idea of what remains that a person in the claimant's position can still do lawfully, which might require her to show her entitlement to do so. I think it's fair to say that she's prohibited from doing so much that the court's absolutely right to say that there's little, that there may be little that she would actively do which would attract a possible check on her entitlement to status. But that would simply underline my point of how miserable it can be to be in that position.
No, well,
for protracted
that I
period of
understand.
time.
This is just on the very specific point of documentation.
I think your junior may have a point for you. Ms. Wilson.
I'm informed by my junior, who I think is informed by my solicitor, who's very experienced in this area of the law, that educational institutions struggle with what the status is of a potential victim of trafficking in the recovery and reflection period, because although individuals in that category are entitled to education.
Are they? I didn't know that.
Yes, nodding all round. So,
not according to Article 12 of the Convention, then, but they may be as a matter of domestic law.
well, this is what I'm saying, and I think it's right that when one looks at the public statements of Her Majesty's government about the broader arrangements made for potential victims of traffic, or indeed entrance into the NRM as a consequence not of trafficking but modern slavery, might be entitled to, it's right to say that Her Majesty's government can and does go further than the Convention strictly requires them to do in some circumstances.
Sorry, I prolonged this bit of your submissions, but what actually is your submission of law about, you helped me because I think I raised the point with Mr. Tapp about what the reasonable grounds letter says about irremovability, and you say nothing.
Yes.
What's your proposition of law based on that fact which you have now established?
Well, we renew the submission we made in front of Mr. Justice Mostyn, and as contained in our respondent's notice, and as set out more fully, in fact, by the intervener in their updated written submissions, that Article 13.1, read with paragraph 178 of the explanatory report, place an onus on the UK to provide some formal authorisation. I'd make 2 points about...
Hang on 1 second. And that's an independent point from the point about actually being entitled to a form, or to be considered for a form of discretionary leave. Or is it just...
It's not an independent point, because we say that the Articles 10 to 13 can be and should be read together. And we accept that signatory states, such as the UK, have a discretion how to meet those obligations, which must, of course, coincide with their own domestic legal arrangements regarding immigration. That's right. However, the Secretary of State has a broad discretion under Section 3 of the Immigration Act 1971, and it's open to the Secretary of State to consider a range of solutions to regularising a person's status in the interim. So, for instance, in the case of overseas domestic workers, the Secretary of State has made an order, variation of Leave Order 2016, which effectively applies the 3C prolongation requirement to the situation of domestic workers. And that's actually dealt with in a bit more detail in the written submissions of the intervener. So that's one way of dealing with the situation. Another way of dealing with the situation would be, as the Secretary of State does in the case of cases where there's a pending family case. So, for instance, if a person is facing deportation, but the Article 8 factors relating to their deportation involve what a family court might conclude about the relationship with a relevant child, then the Secretary of State will grant some form of interim leave pending determination of those matters by the family court. So there are a range of options that the Secretary of State has for regularising an individual's leave in the interim.
Hang on 1 second. I'm just looking at how respondent's notice doesn't. Respondent's notice that we have at the core bundle at 39.
Yes.
Which raises this point, why I've been exploring it with you.
Yes, the Article 13(1) point, yes.
It is a respondent's notice for upholding Mr. Justice Mostyn's order. It's not for saying that he should have made a different order. We haven't actually got, this isn't on, where's the actual respondent's notice form? This is presumably the attachment to the respondent's notice, but the actual form requires you to say which, but looking at the text here, it's clear which.
I don't have the form to hand.
Well, it doesn't, well, someone better just check it, but looking just at paragraph 1, respondent seeks to contend the order of the court below should be upheld for reasons other than. So,
we say that the clear intention of Mr. Justice Mostyn's order was to reflect 10.2 as a gateway provision, and the gateway provision includes Article 13(1). So it's.
No, that's fine. I'm sorry. All I'm just trying to identify to myself is exactly whether this is, as I think you are clearly putting it, a supportive argument, but not one that one which Mr. Justice Mostyn rejected.
Yes.
But you nevertheless wish to rely on.
Yes.
For the relief which he in fact granted.
Yes.
You're not saying, well, if we lose on the relief he granted, we at least want this lesser form of relief.
I may need to take some instructions.
Well,
on that.
I can see what you're saying.
Yes.
By all means, take some instructions, but perhaps not now. But perhaps we ought to just see the formal respondent's notice rather than this piece of text, which obviously went with it.
Yes. But it's my submission that Article 13(1) isn't to be viewed in the abstract or in isolation. It's part of the constellation of rights and entitlements that a person who's passed through the gateway of 10.2 is entitled to. Without 10.2, there would be no 13(1) for this individual. It's going through the 10.2 gateway that gets her to 13(1) at all.
Thank you very much.
So I had two submissions to make about consequent on my submissions on Article 13.1. The first relates to the way that previous courts have looked at Article 13.1, and I think it's fair to say that there certainly have been authorities in which the availability of temporary admission, and I'm thinking of FM at tab 45 of the bundle, of the authorities bundle, has been treated as sufficient for the purposes of Article 13.1 authorisation. I don't know if it does it in terms, and it may be that I have to turn up at M1 to get that. But the we can see at paragraph 14 of
Sorry, paragraph 14 of what?
yes.
Of what?
Oh, sorry, paragraph 14 of tab 45, the case of FM,
Sorry, just let me
electronic number 1693. Tab 45 of the authorities bundle.
Which paragraph in the authority was it? I can't remember.
Paragraph 14.
14. That's on electronic page 1699.
So the point I wanted to make about this,
Sorry, can you just help me on this?
yes,
Mr. Mott refers to the grant of temporary admission,
yes,
which I know is a concept one is broadly familiar with in the context, particularly I think, of asylum. But outside the VOT context, if someone is temporarily admitted, are they given a letter saying you're being temporarily admitted under whichever power it is? I just don't know what formally temporary admission is.
yes. My point is that there is no longer such a creature as temporary admission following the coming into force of Schedule 10 of the Immigration Act 2016.
Because it's now immigration bail.
Yeah, well, what the Act did was to reduce the various forms of status that a person unlawfully present in the UK might have to only one status, of illegal migrant, who is liable to detention and therefore, if at large, on immigration bail.
So, sorry, is what you are saying that since the abolition of temporary admission, and I think the intervener is helpful on the history of this, but
Yes,
I forget, what date was that roughly? Before the time we're concerned with anyway.
yes,
But since the abolition of temporary admission, there is no formal status for someone in the position of a victim of trafficking who doesn't have other leave, other than what can be inferred from reading the NRM in line with the requirements under ECAT.
that's right.
So it is clear, I'm sure, from the NRM, perhaps you've referred us to the passages, but I don't have them to mind, that they are irremovable.
Yes. Instructions.
But that's not turned into a formal status within the immigration structure of this country.
No, because there is no longer the option of temporary admission. So that may have been the alternative, the option, but that option is no longer available, and so there is nothing more than the RG letter that the court's seen.
And do you submit that Article 13.1 requires something more?
What Article 13.1 requires is a legal framework and an authorisation. And so we say that some form of document setting out what the legal basis is of a person's entitlement to remain in the UK. But we don't make that submission in isolation from Articles 10.2 and 12.1 and 2, or the overarching objectives of ECAT, because the form that document should take and the rights which it may have must have a better relationship with the rights and entitlement of 12, set out in 12.1 and 2. So they must have, it's not sufficient, certainly not for EOG's purposes, but it's not sufficient to say, to meet the obligation under 13.1, here's a document saying you can't be removed. That would not meet the objective.
But that letter was also addressed to the contractual provider of support and accommodation as well, which obviously goes or is directed to 12.1.
Yes, yes. I'm not saying that that the document that's given is in isolation from those obligations. Plainly not, because the NRM, the purpose of the NRM, as we've identified, is clear. But what we're complaining about is the lack of guidance being given to decision makers about the circumstances in which something more than a RG letter might need to be provided, because of its impact, because of the various matters that Mr. Justice Mostyn took into account. Simply to say you can't be considered for any form of leave until you've got a CG, in my respectful submission, whether you describe it as a policy lacuna as Mr. Justice Mostyn did, or as simply a fettering discretion, or in the terms of IJ Kosovo and the other trafficking cases, a failure of the guidance to reflect accurately the duties. However you describe it, a decision maker is not permitted and not assisted to understand the relationship between the need for a document, the rights and entitlements which accrue to a person who's passed through the 10.2 gateway, and their particular personal circumstances.
This is an odd way of putting it. I can understand. Mr. Justice Mostyn's decision, which is the primary decision that you uphold, is, if you look at the terms of his declaration, that he failed to have a policy for granting discretionary leave in appropriate cases.
Yes.
I can understand that conceptually, but there is a distinct point, which is, even if you're not entitled to discretionary leave, are you entitled to something to show what your status, ex hypothesi, less than discretionary leave, is? You've clearly got some status, just you're irremovable.
Yes.
But you're saying, and indeed the respondent's notice shows this, that that's not actually a freestanding form of relief, that you are some lesser way in which you might have lesser victory in the case if you don't win on your main point. You're saying it's only relevant. It's only relevant as an example of the things that such a policy should cover.
Well, yes, because of course the terms of the policy is something that the Secretary of State, as Mr. Justice Mostyn identified, has to formulate.
Well, you haven't actually taken us to what Mr. Justice Mostyn said, or the terms of his order. Shouldn't we look at that?
106 of the
106.
core bundle.
I mean, I don't personally see how you can advance this argument without having formulated some other order that you want. Because all he says is she's unlawfully failed to implement obligations under 10.2 because she doesn't have a specific policy concerning the circumstances in which and the terms upon which appropriate grants of interim discretionary leave may be made.
The first observation I would make is that references to policy are to guidance. So what's to be understood from references to not having a policy is not having guidance, effectively. The policy that we rely on, obviously, is the overarching policy commitment to meeting the obligations of 10 to 13 of ECAT through the NRM and guidance. But the reference that Mr. Justice Mostyn makes to 10.2, we say must necessarily include what else, the other parts of ECAT, which necessarily come into play once the gateway of 10.2
if you look at paragraph 48,
yes.
he says in the middle of the paragraph, and this is absolutely the meat, although we then got to look at what he actually ordered, the defendant must formulate a policy that grants such persons interim discretionary leave. That's what this case appears to be about. And then if you look at the order, which is the next item, which is page 106, that page in fact, he's unlawfully failed to implement her obligations under 10.2 because she does not have a specific policy concerning the circumstances in which appropriate grants of interim discretionary leave may be given. So there's no real room for an argument about some halfway house short of discretionary leave, which is required to be given as a result of the final sentence of 31 as glossed in the explanatory memorandum at paragraph 178. It's not just a technical point, because I want to know exactly what you were saying.
I understand. Discretionary leave in that context is leave granted by discretion. So it's leave which the Secretary of State has a discretion to grant outside the immigration rules by virtue of the Secretary of State's broad powers under Section 3 of the 1971 Act. It's difficult to know how else to describe it.
Well, I'm not sure that's right, because we all know, although it happens to have been abolished, but conceptually it's perfectly possible to have a form of lawful, argue about exactly what's meant by lawfulness, but broadly speaking, lawful presence short of discretionary leave. It used to be called temporary admission, and now that happens to have been gone. But that is not discretionary leave.
In my respectful submission, as things currently stand on the law, there is no such thing as a form of leave which is a form of escape from unlawfulness. The 2016 Act makes it quite clear, and that was the intention of the Act, to reduce all persons who are unlawfully present in the UK to one status only, that of illegal migrant.
Yes, but there is no suggested order that you have put forward which goes beyond the very clear order that Mr. Justice Mostyn made. Mr. Tam says that order was completely illegitimate, but you say, no, it should have said something different. But unless we see what you actually are asking the court to order in its place, it's very difficult for us to determine this issue at all. Because it's all very well to say, well, you could have done this and you could have done that. But what do you want the court to order if it is wrong, as Mr. Tam says it is, to make the declaration at page 106? I mean, no, it's not.
It's our position, it's our primary position, that the order made by Mr. Justice Mostyn was one that he was entitled to make.
I know.
On the findings that he
you
did.
started your submissions with your respondent's notice. which is an unusual place to start, if I may say so. So what I'm asking is, if you are arguing your respondent's notice at this point, one of the criticisms that can be made of it is that you're not telling us what is the order he should have made. Now, if you say, well, I'm not because I don't want any alternative order, which I think is your submission, then you have to say how the order that was made is supported by your respondent's notice. And at the moment, that's the bit I don't see.
I would need to take instructions over the luncheon adjournment about what, if any, other order, alternative form of order is being sought. That certainly, my Lord is quite right, hasn't formed part of my case thus far. But we do say that the order made by Mr. Justice Mostyn was...
Well, you say it's right.
Yes.
So one approach to your submissions might be to start by telling us why Mr. Tam's ground 1, for example, is wrong.
Yes, well, forgive me, I had understood that that's what I was doing by reference to the way that Articles 10.2, 12.1 and 2 and 13.1 fit together.
Well, I've got that submission. Yeah.
And it's on that basis that we made that submission. That's why I had to deal with the respondent's notice first, because we say that that the arguments relating to 13.1 aren't freestanding. They form part of the gamut of obligations that arise when a person passes through the 10.2 gateway. Just going back, if I may briefly, to the order made by Mr. Justice Mostyn, it's clear from the terms of the order made by him that the content of the order is a refinement of what's in paragraph 48 of the judgment.
Sorry, it's a refinement of?
What the court's just referred to in paragraph 48 of his judgment. And we recall, of course, that appeals are against orders.
Well, what's the refinement?
So,
I mean, I'm looking at 48. It says the defendant, I mean, my Lord just read it out, and he then read out the bit that is in the order, which is remarkably similar.
yes. But he points out that it's the absence of guidance. He refers here to a specific policy, but we know here that that means policy guidance concerning the circumstances in which and the terms upon which appropriate grants of interim discretionary leave may be made. Now, he doesn't there set out what the circumstances are or the terms are. Simply that the guidance itself should indicate what those are.
Well, that's really what he says in 48, because in 48 he says she should have a policy on this, and I agree with Mr. Tam that constitutionally that's a matter for her, but the terms must obviously be lawful, and I'm now giving you some ideas, your time-limited right to work, etc., etc. But obviously it wouldn't have been appropriate to put that in the order, because that was just, as he accepted, something for her discretion.
Indeed, my Lord, it's perfectly proper and indeed reflects the approaches taken in Atema 1, IJ Kosovo and various other trafficking cases to say that the guidance given to decision makers doesn't reflect the content of the obligations in ECAT. So this is, the language of Mr. Justice Mostyn is basically to say in his declaration, your guidance, your policy guidance, doesn't deal with this situation. It needs to set out for your decision makers the circumstances in which and the terms in which he doesn't prescribe or seek to prescribe or tread constitutionally on the toes of the Secretary of State as to what those might be.
No.
Although he appears to be doing so in paragraph 48 of his judgment. So it's clear that this order is a refinement of
I mean, be fair to him, he doesn't. He says, I agree with Mr. Tam that constitutionally that's a matter for the Secretary of State.
But it's right that the courts have held guidance to be defective because it doesn't reflect or is silent on.
There's no issue about that, is there?
Sorry?
There's no issue about that.
No.
You're emphasising a point which isn't in dispute.
Well,
the question
indeed,
is
well,
whether this particular,
yes,
in this particular case, the absence of guidance involves a breach of
Yes.
the obligations under
no,
KTT,
exactly.
which we haven't even got to yet.
Yes, that's right. But in principle, in principle, there's nothing constitutionally wrong
No.
with Mr. Justice
We're all
Mostyn
agreeing.
making- Yes. Oh, sorry, that's not the
So
impression
what-
I got from my Lord the MR.
Well, I don't know why you got any different impression. I mean, I'm concerned with having your clear answer to Mr. Tam's submission that it was not open to Mr. Justice Mostyn to require a policy for grants of interim discretionary leave based upon a treaty which said that the potential victim of trafficking would not be removed.
Yes.
Now that seems to me to be a critical question in this case, and I for one would be very grateful to hear what you say about that, because there seems to be, apart from the use of the term interim discretionary leave, which doesn't seem to mean all that much, where does it come from based on Article 10.2, which is what he springs it off? I understand your point about the constellation of provisions and other provisions that might support it, but at the moment I'm troubled by how do you get there at all under Article
10.2? It's relevant to recall that the terms of ECAT apply to a whole range of different countries with different circumstances, different immigration provisions. Many of which will not have a hostile environment, and many of which may not have the long delays which are bedeviling the NRM in this country.
I'm not sure that's the experience of the courts when dealing with extradition requests and other matters. I'm afraid it seems to be a systemic problem around all those signatories of ECAT, but anyway, that's neither here nor there. I think you're perfectly entitled to say they're different environments.
I think they are, but Mr. Justice Mostyn correctly, in my submission, identified that ECAT envisions decisions to be made and much more swiftly than they are in fact made. And
But that's a two-edged, you may well be right about that, but that's a two-edged sword from your point of view, because it might mean that it doesn't contain any requirement to give anything other than quotes temporary admission, precisely because that its expectation is that the interval between reasonable grounds and conclusive grounds will be short. But that's a problem for you. It's not an advantage for you. You can't say, well, if ECAT had realised that, it would have included some other provision if in cases where the delays took a long time.
my lord, it's not a problem for me, and it's for this reason. The remedy proposed by EOG and ordered by Mr. Justice Mostyn was one which required the decision maker to reflect on the particular circumstances of the individual caught between an RG and a CG, including delay. It may be that the Secretary of State would divine a policy which said, we're not going to grant you any interim leave unless you get past this 6-month threshold, say. Or we're not going to, only in unusual circumstances will the Secretary of State be willing to regularise the leave of the status of an individual where these other factors aren't present. I mean, all these options are open to the Secretary of State on the formulation of the relief provided by Mr. Justice Mostyn.
Yeah. But where does where does ECAT demand that there is?
But I have never. ECAT doesn't demand it, and it's never been part of my case that ECAT or Article 4 mandate a particular solution of a regularisation solution in the interim period. What's complained about is on the current situation, a decision maker can't consider those factors. They can't look at what impact being a victim of trafficking has on a question relating to regularisation until a CG decision is taken. It's perfectly possible for the Secretary of State to formulate guidance which says we will not normally grant a form of interim leave unless these circumstances are in play.
I mean, she can do, but why is she obliged to do so?
Because of the factors that Mr. Justice Mostyn identified, plus Article 13.1. And that is to say, the evidence about the impact on a person in the recovery and reflection period, the impact on the aims of the Trafficking Convention in combating trafficking, the disincentive to enter the scheme. All these factors were material to the exercise of a discretion whether or not to regularise the status of an individual in that interim period, having regard to things like delay.
I mean, that is coming very close to saying that the treaty and all its objectives have the force of English law, which you accept they don't. The only thing that is justiciable here is the policy expressed by the Secretary of State. If she says, I intend to comply with Article 9 to 13, then that can be justiciable. I think it's accepted. But it's not open to you to say, well, the whole ethos of the treaty is to be considered as mandatory provisions of English law.
It's orthodox, my lord, for the court to construe or interpret the provisions of Articles 10 to 13 in accordance with the aims of the Convention as a whole, and that's and to take a purposive approach, and that's Article 31 of the Vienna Treaty. It's a perfectly orthodox approach to considering what.
So there's really no difference in your submission. Once the Secretary of State has said she intends to give effect to, say, Article 10, it doesn't matter. Everything, it is just the same as if Article 10 and all its rationale had become a provision of English law. Just the same. Because you can take everything into account, and she should be given full statutory effect.
No, just construed consistently with. You couldn't construe.
I mean, you see, forgive me, I'm a private lawyer. When words are written on a page and they say something completely different from what somebody is saying they mean, you can't just wave your hand and say these words mean something different because the intention of the legislation, the treaty, was to achieve good things. You have to have more substance to it than that. And at the moment, the only substance I'm hearing is Article 13.1, right, which we've looked at carefully, we perhaps should look at again. But I don't at the moment see how Article 13.1 can change the words written on the page that the treaty provides for, namely that she shall not in that period be removed.
Well, I think it might be helpful then to turn up
Yes.
the formulation in 12.1 and 12.2 about how the provision of support has to, and the measures have to be those that are considered necessary in the
Yes.
individual circumstances of the
Yes,
person.
got it very strongly in mind. Each party shall take due account of the victim's safety and protection needs, adopt the rules under which victims lawfully resident within its territory shall be authorised to have access to the labour market. etc.
So we're here concerned with Articles 12, 1 and 2, and we're at tab 14, Authorities Bundle 573. Each party shall adopt such legislative or other measures as may be necessary to assist victims in their physical, psychological and social recovery.
You have to read that with the next, which then sets out certain specific things. Isn't a sensible reading of this, at any rate, when looking at a domestic policy, that it must be for the policy judgment of the Secretary of State to decide what she regards as necessary to assist victims in their physical, psychological and social recovery. So that's ultimately a judgment. What she can't do, however, is not do the things set out at A to F, which are specific mandatory things, which the Convention says this at least you must do. So if she denied access to emergency medical treatment, that would be a breach of the Convention. And if her policy said she was going to comply with 12.1, she would have misdirected herself in applying the policy. But you can't point to any specific provision which says they must grant discretionary leave. All you say is if you don't grant discretionary leave for a long period while waiting a delayed conclusive Brown's decision, that may be and often will be adverse to psychological and social recovery.
Well, I go a bit further than that, my lord, because I say that a decision maker is not permitted under the current policy guidance to ask themselves the question whether the measure of regularising leave is necessary to assist victims in their in their physical, psychological and social recovery.
But I suppose there's another element to this, which is that it's not at all clear to me that Article 12, which is about assistance to victims, says anything about the basis of stay. The basis of stay is addressed in 10.2, which is irremovability, shall not be removed. And it's quite clear to the draftsman that that is different from renewable residence permit. They're different concepts.
I accept that, but
And
we're not here talking about
and
residence at all, my lord.
Sorry?
We're not here.
No, well,
talking
of course
about
you're not,
context
but the point is that given that that is different, all that 10.2 requires, all the group of provisions between Article 10 and 13 require, is a status of irremovability. And while you're there irremovable, waiting for your decision, you're entitled to the assistance under 10.1 and 10.2. Where do we get an obligation to grant some form of permanent immigration status? I think permanent is the wrong word. residence, I suppose, is the language of the convention, during that period.
My lord,
You're saying there ought to be one, because otherwise the effect is, if there's long delay, deleterious to the victim of trafficking. I understand that, but I don't see it in the convention.
My lord, I obviously, and my lord is quite right, I don't seek to elevate the combined effect of 10 to 12, 1 and 2 and 13, 1, to mandating some form of residence, or even providing a basis for the argument that succeeded in front of Mr. Justice Mostyn relating to specific residents. What I'm talking about is the difference between tolerating a person's unlawful presence and over a protracted period, and recognising that a person is here lawfully. Now, how the Secretary of State would do that, in my respectful submission.
What does lawfully mean? In one sense, they are here lawfully. In one sense. In another sense, I accept they're not.
Well, they're not in domestic law. They're not here. According to domestic law, they are a person who, in the position of the claimant, is unlawfully present.
What do you base that on? Are you basing it simply on the fact that it's a criminal offence?
A person who requires leave and doesn't have it is unlawfully present in the UK.
It does Section 3 say that?
This is the
I'm
1971 Act.
I'm not getting it. I'm literally just trying to understand.
Yes, it's the
what
immigration.
is meant. You may say, by now I ought to know what lawful means, but actually it's quite a tricky concept.
Yes.
And if there is some provision in Section 3 of the Immigration Act or somewhere else that says if you're here without leave, you are unlawfully present,
Yes.
I'd like to see it.
I think it might be Section 33, definitions of the Immigration Act 1971,
Well,
which
show
aren't
me
in.
then.
Sorry, you went too quickly for me to catch that section.
Sorry,
Section what?
I think it might be Section 33, the definition of an illegal.
Well, I didn't say it might.
Illegal person.
Show us,
yes.
and we'll know.
I don't think we have that. We have that in. No, my juniors. But I can get it over the short adjournment.
All right, but I'm genuinely not. This phrase "lawfully present" is banned. I thought you were going to say, "Oh, but because it's a criminal offence to be here," and then I would just like to have been talked through exactly how that works. But in one sense, they're clearly not unlawfully here. The government has said you may be here. We're happy for you to be here while we make up your decision. And indeed, not only that, but we're giving you various rights. You say not good enough rights, but rights. So in one sense, they're not unlawfully present at all. They can't be expelled.
According to domestic law, Parliament has provided that you are unlawfully present.
Well, you keep saying that, but you haven't shown us the
yes,
provision.
I understand that, my lord, and I'm happy to
well,
get those provisions under
thank
you. It relates back to what I was saying before about there being a sort of a range of statuses that you might have if you required leave but didn't have it, and that the 2016 Act has reduced that down to one status. I wonder if it might be helpful at this point just to turn up Schedule 10 to the 2016 Act so the court can see what those provisions provide. We're at
Page 821.
yes, I'm grateful. Tab 25 for anyone who's working on bundles.
I mean, could you just help me with the section you have in mind? Is it section 33, the interpretation of
Yes.
chapter 1? Because looking at that, that has absolutely nothing about, that I can see, about status. What's the definition that you think would give us it?
I thought it might be the illegal entrant, but
Illegal entrant.
or There are a number of statuses set out there. I'm doing this off the top of my head. I think
No,
it's
no,
probably
okay.
better if I
No, no,
undertake
it's
to
fine.
get the
Fine,
chapter
I'm
and
just
verse to the court
trying to
over
help.
lunch and adjournment.
Yeah.
So, the main provisions of Schedule 10 are set out at 822, and we can see there a list of persons who are, in respect of whom bail can be granted. And that relates to powers of detention of persons unlawfully in the UK. And then...
Sorry, section, did you say? I was just writing something down.
Sorry.
Which paragraph are we on?
We're in Schedule 1, Paragraph 1.
Schedule 1. You've got Schedule
Sorry,
10.
sorry, Schedule 10. Forgive me.
Schedule 1.
And where were you reading about persons unlawfully in the UK?
It's the a number of categories of persons liable to detention is set out in subparagraph 1.
Yes, but I can't see that. I may be just being blind. Where's the phrase unlawfully
It's
present?
not there.
Oh, I see.
And then subparagraph 5 provides that a person may be granted to remain on immigration bail even if the person can no longer be detained, and then sets out 2 categories there. I had understood that there was a reference in Schedule 10 to the underlying status of the individuals liable to be detained, as indeed the claimant is, but I can't see it there. I'm going to have to go back to the 1971
Yes,
Act
I
and
mean,
provide those.
a typical formula you find is who requires leave to enter or remain but does not have it.
Yes, indeed.
And for all I know, there will be somewhere that
Yes,
calls that
I'm sure there
unlawfully
is.
present. I just don't know where it is.
And forgive me for not being in a position to provide that to the court now. So, just going back on my Lord's question about where 10.2 doesn't make any specific positive provision for the grant of any form of regularisation, we say, notwithstanding that, when one looks at the way that the 10.2 and the gateway provisions fit together, that the consequence of reading those provisions together is that there will be circumstances in which what's necessary, what's a necessary measure under 12.1 may include regularisation of status. And that as things currently stand, decision makers are not permitted to look at whether such a measure is necessary, and may only consider immigration status after a positive CG decision has been made.
Obviously, a key concept in your submissions is regularisation of status, and you've explained that that doesn't have always to be by way of leave to remain. Various options open to the Secretary of State if she's imaginative, or reinstates the concept of temporary admission.
As she did with the imposition of overseas domestic workers.
Well, I'll come back to that in a minute. But that's just a label, isn't it? What are the rights that would go with regularisation that she doesn't have now, that victims of trafficking don't have now? You mean that, is it a code for the right to work and the right to access to benefits? Or what is it?
Well, no, because as the court will know, for instance, from the concept of restricted leave, when the Secretary of State grants leave, the Secretary of State can attach such conditions as she considers appropriate.
It's got to have some substance, otherwise there's no point asking her to look at it.
But that's.
What does regularisation? I still don't understand what regularisation means over and above being told you're irremovable, and perhaps, though you say it hasn't been done, give me a bit of paper saying you're irremovable.
Well, the only immediate effect would be the prevention of visiting on a person, the consequences of being here unlawfully. It doesn't necessarily mean the right to work. This, again, is where Mr. Justice Mostyn clearly left it open to the Secretary of State to consider, for instance, what conditions might be attached. It's certainly not argued by me.
The consequences of being here unlawfully, the checklist that Mr. Biggs went through in Balajigari were criminal offence. Mr. Tam said it's not quite as simple as that, but we haven't looked at it. Maybe we don't need to. Not being able to work, not having access to the NHS, but in fact, in the case of victims of trafficking, they do. Not being able to rent private accommodation, and not being able to drive a car. I think those are the ones. Maybe another I've missed. Is that what you're really saying? That they should have those rights, or some of them?
What I think it would be helpful, if we may, to turn up the interveners' detailed submissions on the consequences of the hostile environment for individuals, because they set out in the updated submissions a very comprehensive description of the consequences which we would say regularisation would avoid.
I mean, you'll deal with that, of course, but in Article 13, which is the article that deals with the recovery and reflection period, it says that the 30-day period, which we know is much longer in reality, shall be sufficient to do certain things, take informed decisions, and escape the influence of traffickers. And during this period, it shall not be possible to enforce any expulsion order against him. So the article upon which you specifically rely contemplates that there may have been unlawful status and an expulsion order, but says, but you mustn't enforce it at this stage. And, of course, Article 12, to which you've drawn our attention, which is specifically referred to in Article 10.2, says that you have to, if I can put it in the vernacular, make the PVOT comfortable in various different ways.
Well,
what I don't see is when you have specific provisions about status and expulsion, how you can imply that there is any obligation. I quite understand how it might be nice to regularise the status, and it might be very much for the benefit of the victim. But we're talking about what this treaty is about. And I just don't see anything in this treaty which provides for the Secretary of State to have to regularise the status at that stage. In fact, the whole structure of it reads differently, which is why just telling me how important it is, I mean, for myself, I completely accept that the period of delay in which the victim has no rights is absolutely appalling. I mean, it's plainly, in many cases, a terrible period in which they are in a terrible limbo. But I am, we are concerned with legal questions here, which is very important with Western West, and that's all we can determine. And what I'm concerned about is Mr. Justice Mostyn seems to have given the Secretary of State a sort of requirement that would be very nice and would be very, very beneficial in every way for victims, but is not grounded in these articles, which is why, for me, the submissions that we've read from the intervener, and no doubt we will hear later, doesn't answer my basic question, which is how you get this obligation out of even the treaty articles that you rely upon. Sorry, that was a lengthy exposition, but it's what's really worrying me, and it would help me to hear what you say about it.
It's always helpful, my lord. I would, however, take issue with my lord's description of Article 12, 1 and 2 we're concerned with here.
No, I'm sorry about the subject.
Making an individual comfortable.
Forgive
It must be right.
You even said that.
I didn't mean it like that. I just meant to summarise Article 12's 1 and 2, which I've read so many times that you have to deal with things, assist the victim in relation to their standard of living, emergency medical treatment, cancellation services, counselling, information, etc. I've got all that. But to try and address the question rather than the formulation of my description of summary of Article 12.
Yes, my lord, the formulation in Article 12.1 isn't prescriptive, it's true, but it is also pointing out the relationship between the measures of assistance which are necessary and the physical, psychological and social recovery.
But it's not about status, as my lord pointed out to you now half an hour ago.
That's right, but again, looking at the measures in the context of in the domestic context in which it has to be applied, i.e. where the consequences of being unlawfully in the UK are very grave, and Mr. Justice Mostyn found, and it's not challenged, that the consequences for this came up were very, very grave of being kept in limbo. If and to the extent that a grant of some form of regularisation, some form of authorisation in the terms of Article 13.1 is necessary to assist a victim in their physical, psychological and social recovery, bearing in mind the overarching context in which that recovery is to be supported. In my respectful submission, it's wrong to say that because regularisation of status isn't mentioned specifically here, that it may not be a measure which is necessary in the individual circumstances of the claimant, of the potential victim of trafficking.
Okay.
In my respectful submission, leaving aside the question of residence, that constellation of rights and entitlements plainly anticipates that an individual who is protected from removal in the circumstances in which the duties are owed under Article 12 and 13 would be here, would be so lawfully protected from the consequences of unlawful presence. It may be in another jurisdiction where the consequences of unlawful presence were not so severe that the obligation to look at the necessity of that measure may not arise. But we say it does arise here in the circumstances of this case and of this environment. I'm wondering if it may be a good idea just to turn up briefly the explanatory report.
Which paragraph?
So if we go to the paragraphs dealing with Article 13 at 621, beginning paragraph 172.
Page?
621.
Thank you, sorry.
And what the paragraphs from 172 onwards plainly identify is the relationship between the recovery and reflection period.
Can I just put to you the first sentence, which is absolutely explicit that a person within that period may either be illegally present in the party's territory or may be legally resident with a short-term residence permit. It says so.
Yes, my lord, but that's simply identifying the class of individual to which these provisions apply, because obviously if you're a national of the country concerned, you're not unlawfully present or you have a permission to remain, then obviously none of these provisions will be necessary. That's all that's doing. It's not contemplating a protracted period of illegality. What it's doing is identifying the class of person within the recovery and reflection period to which the Article 13 provisions must apply.
Well, I mean, it then goes on to say these people are extremely vulnerable because of their trauma and they're likely to be removed from the territory. So their status is precarious by definition.
Yes, but there's nothing in that, with respect, there's nothing in that part of the explanatory report which indicates that condition should continue. What it does is identify, particularly at 178, over the page, to meet this at the end, last sentence. Well, court can read through paragraph 178. I'm sure it's already done so. I know that Lord Justice Underhill has, but in any event.
Well, we did yesterday with Mr. Town.
Yes.
We did yesterday and we had before.
Yes. But it's also important to note that Article 13 says has some important guidance about the reason there's a recovery and reflection period, what it's supposed to achieve. And the two purposes are set out at 173 and 174. So halfway down 173, one of the purposes of this period is to allow victims to recover and escape the influence of traffickers. Now, you'll recall that the evidence before Mr. Justice Mostyn included that the protracted period of illegality was in some cases encouraging victims of trafficking to go back into the arms of their traffickers. Now that's an identified aim and purpose of the reflection and recovery period, which in my respectful submission on the evidence before Mr. Justice Mostyn, there's a direct relationship with the question of prolonged unlawful presence. And then the explanatory note continues at 174 that the other purpose of this period is to allow victims to come to a decision on cooperating with the competent authorities. Now that's important because, as I pointed out previously, I'm not seeking to draw in into 10 to 13 the meat of every other part of the convention as my lord suggested to me that I was. What I'm doing is quite properly drawing the court's attention to what the explanatory report says about what the purpose of the recovery and reflection period is. And it's right to say that if, as Mr. Justice Mostyn identified, there is a real problem about achieving the aim and purpose of the recovery and reflection period, owing to the prolonged period of illegality and the consequences set out, I've already referred to, set out in detail in the intervener's submissions, then it's right that what may be necessary in those circumstances is to regularise the position of that person. Again, I don't draw from that the necessary conclusion that there must be a grant of leave, and neither did Mr. Justice Mostyn. What I draw from that, with respect, is that in some circumstances there will be, and as things currently stand, that's not something that the decision maker can consider with this. With these duties, guidance, aims and purposes and objectives in mind. As things currently stand, it makes no difference at all to a decision maker that a person is a potential victim of trafficking. There is no policy which advises or guides a decision maker, there is no policy guidance that advises a decision maker about the factors which are relevant to the exercise of a discretion to regularise the position of a victim of trafficking, a potential victim of trafficking, during the recovery and reflection period.
But the position is, as you yourself said, the drafter, drafters almost certainly, had in mind that the period between a reasonable Brown decision and a conclusive Brown decision would be much shorter than unfortunately it has turned out to be in this country, and it may well be in many others. They probably didn't think it would be 30 days. 30 days was a minimum. We see from further down that there's reference to some countries having 3 months and Greece having suggested 3 months. But we're still talking about a comparatively short period. And that means that questions of regularisation simply are not likely to arise. They've only arisen for the reason you yourself have drawn attention to, that I associate with stuff what my Lord said, I mean, completely wrongly, these decisions have taken far too long to take.
With my response is that none of what my Lord has just said would undermine the submission I make about what may or may not be necessary in a particular set of circumstances.
You say necessary really means you've got to make a judgment in the circumstances as they are. Yeah.
You've got to make a judgment in the circumstances they are. What you can't do is fetter the discretion of the decision maker, close them off to the possibility that on the circumstances of this case, in light of the particularly unusual length of delay or consequences for the individual, it may not be necessary in this particular case. And that's as far as we go. Mr. Justice Mostyn left it 100% open to the Secretary of State to identify the facts and circumstances which should be taken account.
Just before we leave the explanatory report, really only emphasising a point that's clear already, 175, the reflection and recovery period provided for in Article 13, paragraph 1 should not be confused with the issue of the residence permit under
Agreed.
Article 14.
Agreed. And that's said, obviously, in light of the authorisation that's identified at 178. So it's clear that the Article 13, during the recovery and reflection period, some form of status protected status is contemplated, and obviously that has to be considered in the context of the particular regime in the country concerned. Here we happen to have a regime where a person in the claimant's position is unlawfully present, and I'll come back to the legal basis for that submission after the short adjournment. In other cases, in other countries might have other arrangements to provide authorisation according to their own terminology and their own domestic arrangements. But we say that the absence of such arrangements here is part of the factors that the Secretary of State has to bear in mind when formulating guidance to decision makers. It's part of the picture. And I, at the risk of repeating myself, I go back to what I opened my submissions with, which is the central importance of putting a claimant in a position where they can properly support and assist the police with bringing their traffickers to justice. I hadn't taken the court to the guidance expressly dealing with the position under Article 12, which begins at 146. But it's clear.
Sorry, where are you going? 146 of what control?
Sorry, it's paragraph 146 of the explanatory report, page 617 of the so at paragraph 150, the aim of the assistance provided for in subparagraphs A to F is to assist victims in their physical, psychological and social recovery. The authorities must therefore make arrangements for those assistance measures while bearing in mind the specific nature of that aim. And then it's important in my submission that to recognise that
151 as well. We need to read.
Yes, I certainly. I don't say that the. I don't say that paragraph gets me any further. I don't say that I can rely on that paragraph to say that the Secretary of State was required to do anything. What I'm relying on the guidance to do is to point out that there's a clear relationship between the measures which any given state should take in pursuance of the objective of the victim's recovery and the reasons for it. Which is going to arise differently in the context of the state in which the obligation is being met. Again, those particular forms of assistance aren't exhaustive of the obligation that arises.
Isn't that what 151 says they are?
That's a general. That's just the what the list of measures set out in 12.1 covers is not coterminous with what's in the first line of the
Well, the structure, I put this to you before, the structure appears to be there's a general obligation,
yes.
or a general statement of principle, perhaps might be a better way of putting it, and then there are certain specific things you must cover. It is the specific things which are the legal obligations. The drafters wish to make it clear the assistance measures referred to are minimum ones. Although there's no legal necessity to do so, you may give more. Now, it might be possible to read Article 12 differently, but that appears to be how the explanatory report explains the relationship between the general principles in the first sentence and the particular obligations introduced in the second sentence, A to F, whatever it is.
In my respectful submission, it's not appropriate to read the article in that restrictive way, because the words used here are such assistance shall include, but it doesn't, in my respectful submission, qualify the obligation to shall adopt other measures as may be necessary. In my respectful submission, that requirement makes it clear that if there is a measure not included in the assistance set out at A to F, but is nevertheless necessary, it's a measure that should be taken.
Well, I mean, again, at the risk of construing it on the basis of the words used, the second sentence makes it perfectly clear that the mandatory parts are those that are listed.
I'm just...
It does not say you are mandated to do whatever is necessary to assist the victims in their psychological recovery. You shall adopt legislative measures and other measures as may be necessary to assist, and that assistance shall include. The words do have to be given some kind of meaning according to what they say. I understand the purposive construction of treaties, but the purposive construction is not used so as to mean the direct opposite of what the words say.
My submission would be that if there was a measure that was necessary in the terms understood in the first sentence of that, but which wasn't included, but if it was necessary, it would be a measure that would have to be taken. May I turn my back for a moment? Yes, my learned junior has just characterised paragraph 151 as a general observation in respect of the convention as a whole, rather than any limitation on the obligations set out in the first paragraph of that article. I'm looking at the time and wondering whether now might not be a convenient moment.
If it's a convenient moment, Miss Weston, for you, it's a convenient moment for us. Sit again at 2 p.m.